Krista Robey and Maureen Reynolds versus SPARC Group. May we please have appearances of counsel?
Good morning, and may it please the court. Jeffrey J. Greenbaum, Sills, Cummins, and Gross. I'm here with my colleague, Michael S. Carucci, for petitioner, and I'd also like to introduce to the court Michael D. Muti from the Ohio Bar, who has been admitted pro hoc vice, and with the court's permission, will be arguing this morning.
Morning, Your Honors. Jeffrey Jacobson, Fayuri Drinker, on behalf of the U.S. Chamber of Commerce and the New Jersey Civil Justice Institute. Thank you for letting me be here.
Good morning, Your Honor. May it please the court, Stephen Denitis from Denitis Reception and Prince, representing plaintiffs Robey and Reynolds.
Good morning, Your Honor. Vivian Lee on the Attorney General.
Good morning, Your Honor. Barry Classic Selling, Cohen Classic Selling Law, on behalf of the case carrier of the New Jersey Association.
Good morning, counsel, and welcome. Mr. Muti, please.
Good morning, Your Honors. May it please the court. My name is Michael Muti from Benish Friedlander, and I'm here representing defendant petitioner SPARC Group. I'd like to reserve 5 minutes for rebuttal.
We'll have you back, perhaps for a little less. Please go ahead.
The court should reverse the appellate division's conclusions that the plaintiffs alleged an ascertainable loss under the Consumer Fraud Act and that they are aggrieved consumers under TICWINA. The case presents a straightforward issue. Does a consumer suffer an ascertainable loss or an adverse consequence when she receives the precise goods promised for the exact price agreed upon? The answer is no. Here, plaintiffs received the full benefit of their bargain. They bargained to exchange a particular amount of money for a particular bundle of goods. They paid that amount. They received those goods. They have therefore received the benefit of their bargain. Accordingly, the plaintiffs here did not suffer any ascertainable loss under the CFA and are not aggrieved consumers under TICWINA. The court held plainly in Tiedemann that without an objective difference between what was promised and what was received, there can be no ascertainable loss. Here, plaintiffs offer no objective discrepancy. Instead, they offer only subjective disappointment. And the court held in Tiedemann that that will not suffice. We can use Plaintiff Robey's sweatshirt as an example. She picked it out in person, intending to pay $24 for it. She paid $24 for it and left the store with the very sweatshirt that she had picked out. She retained that sweatshirt. She's never suggested any objective disparity between what she bought and what was promised. There are no complaints about the fit, no complaints about the material, no complaints about the style, workmanship, or so on. She suffered no ascertainable loss. Now, the touchstone of an ascertainable loss is a customer receiving less than what was promised. And the difference between what was promised and received must be objective. Subjective disappointment cannot suffice. Only if there's an objective discrepancy can there be a loss. And this court's authority makes plain that in order for that loss to be ascertainable, it has to be quantifiable and measurable, not hypothetical or illusory. Here, the plaintiffs have proffered two theories for ascertainable loss: benefit of the bargain and out of pocket. Neither of them works. Let's start with the benefit of the bargain theory. Here, plaintiffs have received the benefit of their bargain. To show that the benefit of the bargain was not fulfilled, a plaintiff needs to show an objective difference between what was promised and what was received. Tiedemann shows as much. There, the plaintiffs received cars with defective fuel systems. They expected to receive cars that worked without defect. The seller fixed the defect under the warranty, but the plaintiff sued, contending that because they received defective vehicles, they didn't get what they expected, and that the defects would diminish the resale value of the cars. The court concluded that the plaintiffs had not alleged an ascertainable loss. The analysis noted that an ascertainable loss claim will fail unless the difference between what was promised and what was received is, quote, objectively ascertained and is not defined by subjective wants of the plaintiffs, close quote. And that's at 183 NJ 244. The plaintiffs' claim failed there because they offered no diminution of value of either their property or their objective expectations. And the court emphasized again at page 252 that subjective assertions just cannot suffice. Plaintiffs' proffered out-of-pocket theory doesn't work either. They can't establish an out-of-pocket loss for multiple reasons. First, under the out-of-pocket loss theory, plaintiffs are entitled to recover their full purchase price, what they seek here, only if the goods that they received are essentially worthless. Plaintiffs have not suggested that here. Instead, they acknowledge that the goods were worth the amount that they paid. That brings me to the second reason there can be no out-of-pocket loss here. There's no out-of-pocket loss unless a plaintiff receives something that is objectively less valuable than the amount paid. They've offered no allegation that that is the case. And third, the plaintiffs retained value from their purchases. They never attempted to return the goods. Instead, they kept them. They can't plead any out-of-pocket loss without alleging that the items they received were less valuable than the amounts paid, and they haven't done that. The New Jersey cases, including cases from this court, have repeatedly held that a set-off is necessary when the plaintiff retains some value from the purchase. And that was true in cases like Cox and D'Agostino, where the court applied a set-off for increased value enhancements to the property at issue. And it was also true in Boston, where the court refused to refund the whole purchase price of a vehicle in an overcharge case, recognizing that the plaintiff had retained the vehicle and had obtained value from it. For all of those reasons, the plaintiffs do not allege any ascertainable loss.
So in this case, plaintiff comes forward and says, among other things, you promised her a discount and you didn't give her one. What's your response to that?
A discount is not a material term of the agreement. Price, by contrast, is. And I searched Westlaw to find any case holding that a discount was a material term of a transaction. I came up empty. But it is black letter law that the price is a material term of a consumer transaction.
So assume that there is deception. Take another case. Is there a remedy when a merchant makes up a false price and places, does the CFA provide for a remedy?
You asked me to assume that there is deception, correct? Okay. Mr. Chief Justice, it would depend upon the case. And I'm not prepared to tell you.
There's a price listed, a reference price as we have in this case, and it's never ever been sold at that value before. It was a fictional price that was put up there to induce the argument that we have in this case, to induce the customer to go forward. Is there a remedy under the CFA?
If the plaintiff could establish an objective difference between what was promised and what was deceived, then perhaps. But not in a case like this, where what was promised and what was received are exactly the same.
What is your response to the Attorney General's argument that consumers care about intangible qualities such as the amount that their discounted clothing they're considering buying used to be worth, but for the timing of being there supposedly at a time of a discount?
That concern over intangibles does not amount to an objective difference. And I'll offer here what my colleague, Mr. Greenbaum, likes to call the poor schnook example. Let's suppose that a month before plaintiff Robey's purchase, some poor schnook had come into the store and spent $60 on the same sweatshirt that Robey bought for $24. Would Robey be any objectively better off under that scenario? She would not.
But let's talk about not the actual purchase that took place, but the fictional price situation. And the regs come out and directly say that's a violation of the CFA. I'm looking at 1345A-9.6. What remedy is there for a violation of that prohibition?
Well, the Attorney General could bring suit to enjoin that type of false price.
And how about a consumer?
56.819 limits a private right of action to when there is an ascertainable loss.
So if there's an ascertainable loss, could there be a viable cause of action?
If there is an ascertainable loss, and here there is not. The ascertainable loss requirement is a plaintiff's ticket to court. And it's important to note here that when the legislature drafted the private right of act provision, it did not provide that any transaction associated with a violation would support a private right of action. Instead, only one that caused a loss. Put differently, the legislature required loss causation, not transaction causation. We can illustrate the two with an example from a different context. Suppose that your stockbroker were to call you up and say, hey, company A is fundamentally sound. They have a new product soon to come out. It's going to go gangbusters. Now is the time to invest in company A. You wire money to your stockbroker. The stockbroker uses that money to invest in company B. You discover this 90 days later. At that point, company B's stock has gone up 20%. Company A's stock has gone down 20%. The stockbroker's misrepresentation may have caused a transaction, but it did not cause a loss. And in the Consumer Fraud Act context, there can be no private right of action unless there is a loss, an objective difference in the consumer's position. Now, note that plaintiffs and the Attorney General rely heavily on first. First does not provide the rule of decision in this case for a number of reasons. First, that case addressed a rare carpet, one that cost thousands of dollars. It did not address a mass-produced consumer product costing less than $100. Second, that case alleged an objective difference between the goods promised and the goods received. Particularly, the carpet at issue there was delivered damaged and smaller than the parties had agreed upon. Here, by contrast, there's no objective difference. Third, in first, all agreed that there had been an ascertainable loss. Here, that's the disputed issue. And fourth, in first, the merchant failed to follow its own written warranty provision. Here, by contrast, plaintiffs never tried to avail themselves of the merchant's return policy.
If plaintiffs had attempted to return the goods and had been refused, then would this case be different?
It would be different. It's unclear whether it would amount to an ascertainable loss, though. Again, in order to establish an ascertainable loss under the benefit of the bargain theory, they have to show an objective difference between what was promised and what was received. Or under the out-of-pocket loss theory, they'd have to show that what they received was less valuable than the price paid. Here, the plaintiffs allege, I bought a $24 sweatshirt and it's worth only $24. That's not an ascertainable loss.
I thought they were alleging that they wouldn't have spent $24 to buy the sweatshirt in the first instance, but were tricked into it.
I'm sorry, Your Honor.
I thought they were alleging they would not have purchased the sweatshirt, the t-shirts, and the jeans in the first instance, but were tricked into buying the items, and therefore the ascertainable loss is the out-of-pocket expense in particular.
I think they may have opted for that theory as well. They've offered a whole lot. You've seen how robust the complaint is here. Again, that theory addresses transaction causation. And to accept that theory as an ascertainable loss effectively reads out the ascertainable loss requirement from 56.819 and replaces it with a requirement that the plaintiff allege a transaction connected with a violation.
You completely disagree with the concurrence then?
We do. We don't disagree with the fact that an out-of-pocket theory can support an ascertainable loss. We do disagree with the conclusion that the allegations here amount to an out-of-pocket loss theory. There's a difference between an out-of-pocket expenditure and an out-of-pocket loss. Here, they've alleged that they spent money, but they've retained value. And for that reason, they have not alleged an out-of-pocket loss.
So
they're not arguing, sorry. And they're not arguing that the value was less than what they actually paid. They are just making the argument that they thought they were getting this bargain, but they paid $24 for something that was worth $24, correct?
That's correct, Your Honor.
Part of your theory, as I understand it, is there's really very few limits to where this theory could go in the world of commerce, in which people buy things for all kinds of reasons and get benefits out of them that sometimes are very subjective. Is that part of your argument?
That's correct, Your Honor.
What you are saying in essence is that the knowledge that one is getting a bargain is not it cannot be verifiable and it cannot be objectively measured. Is that part of your argument as well?
That is.
Can you expand on that, please?
Certainly. As Tiedemann noted multiple times, and as other courts applying Tiedemann have held, a subjective expectation can't support an ascertainable loss. And the examples you can think of here are myriad. If you go to a restaurant, you order the ribeye, and it comes out a little fattier than you would have liked, not quite as juicy as you would have liked, and you think, I wouldn't have spent $50 on that ribeye. To me, it was really only worth $30. You don't have an objective ascertainable loss of $20.
But here plaintiffs aren't alleging that they had, some subjective, idiosyncratic worth to the sweatshirt, or that they thought the sweatshirt would have some idiosyncratic value that it didn't. Instead, they're alleging it was marked at $36.50. I think we're specifically referencing a pair of pants that were marked as $36.50 with a 50% discount to $18.25. And that to them, the pants were only worth the $18.25 because they thought they were getting a 50% discount from the $36.50. And had they known that the pants were always only sold at $18.25, they would not have bought them. So why is that subjective rather than objective, where the difference between $36.50 and $18.25 is easily calculable and is based on what your client allegedly wrote on the price tag?
Well, there's no objective difference between the amount paid and the value received. That's why. If they had alleged that we paid $18.50 for these pants, or $18.25, whatever it was, but in fact, they are objectively worth $15, then maybe there could be an ascertainable loss, but that is not this case.
I'm sorry, how does this compare to a situation where someone thinks they are buying a famous designer? I know nothing about fashion, so I can't think of the appropriate person to quote, but they think they're getting so-and-so's designed clothes, and they get clothes worth every penny of what they paid, but they bought it thinking that it had this extra cachet, and it doesn't because it doesn't, and it doesn't. How is that different from this situation? Would that be a CFA violation?
In a situation like that, Your Honor, there is an objective difference between what is represented and what is received. An objective difference that goes to the inherent nature of the item. It's kind of like a fake autograph. A baseball card with a fake autograph is just a baseball card with some scribbling on it. One with with a legitimate autograph, that is legitimate memorabilia. It's a collector's item.
But if you take it back to clothing, the clothing can still be worn. It will still keep you warm in the winter. It is functional. It's made adequately, so it'll last a few years. All of the sort of objective value is there, but the person in their mind is thinking that they got something that is really worth something extra because of a designer label that was fake.
That is a closer case, Your Honor, but still, I think the distinction there is that the designer, that designer label is part of the inherent quality of the purchase.
So your adversary would say, so is the idea that this is a discounted, very valuable item.
In the difference would be in the designer merchandise example. There is, if you look on the market, there is an objective difference between what a high-end designer's product would be worth, a handbag, a dress, a pair of pants, whatever, and what a non-designer's comparable item would be. And the difference is such that they're trading in two different markets. That is not the case here.
But isn't one of the problems here that it's very hard to determine the objective worth, value, and quality of an item of clothing that sells at many different prices, perhaps because it has a designer label, perhaps because it doesn't, perhaps because it's trendy at the moment, perhaps because it's not. How does one determine that? You argued in your briefs that the price tag does not represent a good's objective worth, value, and quality. And so the original, fictitious or reference price doesn't matter because that does not represent a good's objective worth, value, and quality. How does one determine the objective worth, value, and quality if not by a price tag and when it has these intangible features like trendiness or designer, cachet, or something else?
Your Honor, I believe that cuts in our favor rather than in plaintiff's favor. True, it is very difficult to identify an objective difference in many cases, but that shows why this case is not a good one for a CFA claim. Stepping back, there is no platonic ideal of a $50 sweatshirt. Plaintiffs haven't alleged anything to that extent. They haven't suggested that, well, by putting the price tag on with the reference price that it had, I would have anticipated a greater fabric weight, a higher thread count, metal zipper rather than a plastic zipper. None of that. And as we sit here today, I certainly cannot think of a platonic ideal of a $60 sweatshirt, such that if I got something different, I would be able to hold it up and say, this is not a $60 sweatshirt. When we're talking about prices, we are not talking about an inherent quality of the goods. We're talking only about something entirely separate. But we don't accept the plaintiff's assertion that a reference price is necessarily a past price. The regulations make clear that a reference price can be a past price. It can be a price offered for comparable merchandise by a different merchant. And if that's the case, and the good sells for under $100, a retailer need not say what the reference price is based upon.
Sorry, go ahead.
Isn't that the point sometimes, that the value is in the reference price? The fact that a consumer can say, I have a $60 pair of jeans, or I have a $100 pair of jeans, that reference point matters to them as consumers in terms of displaying the clothing. So if the truth is that it was never worth $100 or never worth any higher amount, but actually worth $18, there's a loss in value of what they were hoping to display by the clothing they chose and the labels that they chose. Isn't that where there's a loss of value in terms of this particular type of item of clothing?
There's not, Your Honor. The label was the same. The plaintiffs were able to display the exact same item regardless of the price paid.
But at a different value point to those who are aware of what that clothing is worth.
I'm sorry, I don't follow.
Anybody seeing that individual wearing that item of clothing might now know it's only worth $18 and not actually worth $100, which reduces its value to people who care about what their fashion appears to others.
When we're talking about mass-produced consumer goods, as we are here, the value is the price at which it sells. And we know that from first. The case that the plaintiffs themselves rely upon says that in order to determine the value of the item in question, you need to look to the replacement cost. Now there, it was a carpet valued at thousands of dollars, sold for over $1,000. The reason that the court turned to the replacement costs was because it was impossible to just go out to a store and buy the same thing in the same size. So in order to determine what replacement costs would be, they had to look to the value on the price tag. Here, we know what the replacement costs would be. It would be the price that you could walk into any, in this case, an Aeropostale store, and buy the same item. In other words, for the sweatshirt in question, it would be the same $24 that Robey spent to buy it. There's no loss there. Now, if returning to the example of somebody who had paid $60 a month prior, the only difference there is entirely subjective. It's not objective at all. If Robey would feel better about wearing a sweatshirt that some poor consumer had spent over twice as much for a month prior, that is entirely subjective. Schadenfreude is not an objective, ascertainable loss.
But given our media culture and the ubiquity with which somebody could identify and find out what somebody else is wearing and know the price, doesn't that change this? This isn't just a random pair of clothing. This is something that everyone in a particular zone of where Aeropostale is could know what that clothing is worth, what it's worth on the person who's wearing it.
I still don't see how that amounts to an objective difference in value. It would be entirely subjective. The beliefs of other people and what the consumer's beliefs about what other people viewing that item might think. There's no objective difference between the value of what was promised and the value of what was received.
Counsel, I take it if your position that there is no ascertainable loss holds the day, then one is not an aggrieved consumer and there's no TICWINA violation.
That's correct, Your Honor. If a plaintiff receives exactly what the plaintiff sought to buy for the exact price, the plaintiff is not aggrieved and therefore cannot be an aggrieved consumer, cannot have a TICWINA claim.
Other questions, anyone? Anything you'd like to add to your presentation?
I'd like to briefly address the injunctive relief claim. There can be no injunctive relief unless the plaintiff has a private right of action. In order to have a private right of action, there needs to be an ascertainable loss. So that's one reason injunctive relief cannot apply here. A second reason is that even if there were an ascertainable loss, plaintiffs would not have a claim for injunctive relief. 56-819 says that a plaintiff who's suffered an ascertainable loss has a private right of action for treble damages and any other appropriate equitable relief. Here, equitable relief would not be appropriate because the plaintiffs don't check either of the boxes traditionally held to be necessary for injunctive relief, the threat of future harm, or the lack of an adequate remedy at law. If there are no questions on that point, I'll reserve the remainder of my time for rebuttal.
Thank you, counsel. Mr. Jacobson.
Thank you, Your Honors. May it please the court, thank you for giving me time to speak. I'm here principally to make sure the two issues that Mr. Muti touched briefly upon and that the Chief Justice just asked about don't get lost in the shuffle. The first issue is there's another regulation here that's not 9.6 that is much more tailored to this particular issue. And the second is, as the Chief Justice has mentioned, there's a $100 a throw Tiquina claim riding around here that is going to swamp the $25 that's at stake in a CFA violation. And this court has never gone anywhere near suggesting that you can make a Tiquina claim out of a price tag. Because, quite simply, there's no provision in a price tag for it to violate clearly established law. But going back to the first point, 9.6 deals with former prices, something that is expressly called out in a tag as a former price charged by that retailer. Mr. Denitis will say that if there is a former price referenced on a price tag, then it's an affirmative defense to say that the retailer sold it at that former price for a particular period of time. I don't know that I agree with him, but it doesn't matter. Because if you look at paragraphs 53 and 70 of the plaintiff's complaint here, they depict with pictures exactly what they're talking about. Paragraph 53 is an entire store 50 to 70% off claim. Paragraph 70 is buy one, get two free. Those kinds of discounts are covered by 9.8, not 9.6. The plaintiffs also plead explicitly that all of the goods in question here are under $100. And what 9.8 says is that if it's under $100, you don't have to state the basis of that percentage discount. Period, full stop.
But do you have to have a basis for that?
Well, Your Honor, the 9.8 and 9.8 talks about different things that can be the basis for it, one of which is a competitor's price.
Does 9.8 say it's okay to make up a wholly fictitious price?
Your Honor, I'm not going to go that far, but
when you read 9.8 and 9.5 together, it looks like the two specific requirements in 9.5 fall by the wayside for an item under $100. You don't have to place information conspicuously on the item, and you don't have to explain the basis. But does it say it's okay to make up a fake price?
It doesn't say it's okay to make up a fake price, and I'm not going to. I would agree with you that if you were completely making it up, this might be a different case. But 9.8 does say that a competitor's price can be a basis for it. Aeropostale positions itself.
An affirmative defense?
Not in 9.8, Your Honor. 9.8 simply says that and if you look at 9.6 and 9.8, 9.6 says, I want to never paraphrase a statute, never paraphrase a regulation. So 9.6C talks about what the retailer needs to prove if there's a dispute about it. But 9.8 simply says if the retail price is less than $100, and if the regular price and the price after any discounts are taken are set forth on the register receipt given to the consumer at the point of sale, which is not in dispute here. Both of those things are pleaded in the complaint. That's it.
That's in dispute that it wasn't actually the regular price.
That's the whole point. Doesn't say regular price, Your Honor. Because 9.8 talks about a competitor's price as being a perfectly permissible way to characterize the percentage discount.
Sorry, so 9.8B2, where it says the regular price and the price after any discounts are taken are set forth on the register receipt given to the consumer at the point of sale.
Right. What
is the regular price if not the original fake price?
If you look at 9.5, which 9.8 is based on, 9.5A2, set forth the basis upon which the former price was established pursuant to 9.6B. In this regard, terms such as competitor's price or words of similar import shall be used, but then it says you don't have to use that if it's under $100.
But do you have to have that? Does it have to be based on a competitor's price? Does it have to be based on a former price charged by that by that retailer.
Your Honor, New Jersey can change the regulations if it wants to, but the regulations say what they say right here and now.
So is it your contention that because the regulations don't spell out that there has to be some basis for this so-called regular price, there doesn't have to be any?
Your Honor, because Aeropostale positions itself as a discount retailer, there's really, and this goes back to Justice Noriega's question about the objective worth of the goods. I mean, and Mr. Mudi's point that there's no platonic ideal of a $50 sweatshirt. I mean, I think that that's basically correct. And so the point is, if what Aeropostale is saying here is that our $24 sweatshirt is comparable to a sweatshirt that a competitor in the region sells at $48, we are within our rights under the regulations to advertise it as 50% off. And we don't have to state a basis for it under this reg.
But doesn't the regulation, when it talks about a competitor's price, really envision a situation where some manufacturer somewhere is sending the same sweatshirts out to different retailers, and some retailers are selling it at X, and some retailers are selling it at Y, and therefore Y retailer knows that X retailer is selling it for $60, so they can say discounted from $60.
So, Your Honor, I'm going to give you two answers. The first is going to be my Tiquina point. The court can hold that if it wishes.
Clearly established.
It will be new, but it will not be clearly established. And there goes the Tiquina claim. I think right there, no further discussion about aggrieved consumer.
Got that. But what's your answer on the CFA?
I think it's ambiguous. I think that there are, I mean, I'm here on behalf of the Chamber of Commerce and the Civil Justice Institute. We have retailers across the state that think this means what Aeropostale thinks it means. This is the first time that my friends in the Attorney General's office have taken this position. This is the first case that's reached this court on this issue. I think that when you are talking about goods like this that are sold in different stores for different price points.
Has anybody ever contacted what it would be the Division on Consumer Affairs that would have jurisdiction over this, right?
Well, I mean, here they are.
Here they are. But I mean, has anybody ever said, let's find out what they meant by this?
I wouldn't know. It's a very good question. I wouldn't know.
So 9.5 and 9.8 appear to deal with percentage off discounts. Does it apply to the buy one, get two free allegation contained in the complaint?
I struggled with that a little, Chief Justice Radner. I think it does. It's not, it's not a former price. It seems much more akin to a percentage discount to me. But again, what Aeropostale does on the register receipt complies with 9.8. And so they're treating it like a percentage discount because if you buy three, they'll show it on the register receipt exactly that way. It's not it doesn't feel like a reference price situation to me, but I think reasonable people could reach different conclusions about that, not for Tiquina purposes.
The arguments that you're presenting as a friend of the court today, have they been vetted at the trial or the appellate division level?
Well, so yes, because at the trial level, Aeropostale SPARC raised both issues before the trial court. It got lost to the appellate division. I think as I reread my brief getting ready for the argument, I think I was a little harder on the appellate division than I should have been because the briefs to the appellate division really gave the 9 point. I don't think 9.8 came up at the aptive. It did come up at the trial court. But here, this court's got to deal with both regulations. I mean,
was the clearly established argument that you're making brought to the trial court? Which is, as I understand it, that if there is a CFA claim in this, it would not give rise to a Tiquina claim because this is not clearly established as illustrated by the debate going on.
The clearly established argument was my broader argument that anything goes if this is a Tiquina claim because, I'm
sorry, I don't understand what you meant.
So I've been thinking about Dugan, and I've been thinking about the fact that Dugan reached this court at the class certification stage where we more or less had to assume that those menus were Tiquina things, notices, signs, whatever you want to call them. And that issue was not before the court because we were dealing with class certification.
But you're saying price tags are not notices.
I'm saying that a Tiquina discusses a notice or a sign or a warranty or a contract containing a provision. And that word provision is sitting there and it means something. And I don't know how a price tag can have a provision. If you have a sign saying no refunds, that's a provision. And if there's supposed to be refunds under the law and you've got a sign saying no refunds, that's a sign that has a provision.
So you're saying if we find that this price tag is within TICWINA, then anything goes. Is that what you were saying? Then
I think so.
Basically, everything is encompassed within it.
I've had a very hard time getting ready for this argument, trying to come up with something that somebody could sue under the CFA that would not be a TICWINA violation if this is. Because
With $100 a day.
with $100 a throw right there, swamping everything. I mean, this court has done yeoman work making sure that TICWINA stays in its box where it belongs and not becoming a $100 statutory damages for every CFA claim that comes down the pike. And I'm very glad I had the chance to be here today to make sure that we could call out that TICWINA claim and make sure that whatever happens with the CFA claim, I think the regulations are sufficiently ambiguous that the TICWINA claim has to go down.
Other questions? Thank you.
Thank you, Chief Justice.
Mr. Denitis?
Good morning, Your Honors. May it please the court. In listening to argument by my adversary and the questions by the court, I think there needs to be some clarification as what this case is about. This case is not about mere subjective disappointment with someone's purchase. That is not what this case is about. This case wouldn't be before the court if that is what this case is about. This case is about a situation where a seller or a merchant creates that expectation when they tell a consumer that a product has an objective worth of a regular price, in this case, $60 on a sweatshirt, and that consumer bases their purchase in part or in whole on that subjective representation, thinking they're getting a deal. And they're not, because it's a lie. And this isn't a new issue that's before this court. In First versus Einstein-Mungi, 182 NJ1, 2004, this precise issue was before the court. In First, as your honors have, I'm sure, read, it sets forth that a person purchased a Oriental rug that was on the price tag, regular price, exactly as here, it's $5,775. It was marked on sale to $1,400, then marked on clearance from $1,190. The consumer made the purchase. It was defective and too small, and its summary judgment, the court found there was a consumer fraud violation. And the issue that went up on appeal to the appellate division and to the Supreme Court was the sole issue that when there is a consumer fraud violation and there is a representative price on a price tag by the seller, is the damage out of pocket, which the defendant advocated, or is it benefit of the bargain, which the plaintiff advocated? Plaintiff advocated, I bought this carpet. I thought it was a $5,700 carpet. I thought I was getting a deal, and I paid $1,190, but being that the court found that there's a consumer fraud violation, I'm entitled to that $5,775. The defendant argued as here, no, that's a windfall, that's inequitable. And the court said, no, it's not inequitable for several reasons. This court said, number one, it's not inequitable. And the court goes on in a very rich opinion as to the pricing regs and the history for them. The court explains it's not inequitable because the defendant is in the best position to set the price. The defendant is in the best position because it knows the market. The court cited to industry commentators and research that price matters and it creates expectations amongst people who rely on them and make purchases based on them. This isn't some new concept. Every normal consumer is a consumer in this room. Every person likes to get a deal. You shop for cars, you shop for whatever you purchase, and you base your part of your purchase in part or in whole on getting that deal. And that deal isn't some subjective, theoretical thing. It is created when it's on the price tag It's created by the seller. And the seller does it with the hopes that the consumer relies on it. That's why they do it. It increases sales. It increases revenue. This isn't some situation where, well, let's just pick a price out of the air. No, they pick a price that they tell the consumer, this is what it's cost. And it creates an objective value. That is objective. And it's an objective value, even better yet, that's created from the seller. And the court said it's not a windfall because we have pricing regs in New Jersey. We have pricing regs in New Jersey that sellers and unscrupulous sellers shouldn't market items at a fake price because consumers rely on them and price matters. And so the court went on to say, not only is our ruling to choose benefit over the bargain over out of pocket. That was the exact issue before the court. Which nature of damages? And the court said, our ruling today is not only intended to make the defrauded customer whole, but to punish the wrongdoer and deter others from engaging in unfair practices. Now,
with all due respect, first is about a defective product. The UCC has a measure of damages for a defective product, which is to put the purchaser where they were if the product had not been defective. And we're not talking about that here. I understand that is perhaps the closest case of the cases that this court happens to have decided, but respectfully, I would suggest it's not very close at all because it is a defective product. We're dealing with here products that were not defective, that were presumably not defective. There's no allegation of that were what the person thought they were getting. The issue is this value to people, which you say is everybody, value to everybody. I'm not sure there's science saying that, but it's presumably some people like getting a bargain. And that's important to them, but it's just simply not the same case as first.
Respectfully, Your Honor, Justice Patterson, I disagree for this reason, and the reason why I disagree is the opinion goes on once it's determined that there is a consumer fraud violation to determine how our benefit of the bargain damage is determined in a consumer fraud violation case. It doesn't make, and I urge the justices to look closely. There's 4 pages of the opinion that talk about the pricing regulations and that the analysis is not only narrowly for a defect case, it is for any Consumer Fraud Act violation case, and specifically what is seminal in that decision.
Respectfully, the entire premise of FIRST is that consumers should get non-defective products. And and this consumer, very expensive product, got a defective product and suffered a loss. And without that premise, FIRST is simply not applicable to this case. I would suggest to you. I'm not saying you don't have an argument, but I'm saying that relying on FIRST potentially would expand the definition of FIRST to a whole lot of different situations where someone is disappointed with a purchase.
Justice Patterson, I respectfully disagree, and I'll tell you why. All FIRST says is it creates a presumption that a seller's regular price on the price tag is replacement value, which under Note 5 is market value.
Again, as Justice Patterson noted, the entire premise in FIRST is different from this case. You started your argument by stating that this case is precisely like FIRST. And again, I respectfully disagree. These cases are not the same. And in FIRST, there was no question that there was an ascertainable loss. The customer received a defective product. There was no question whatsoever that there was a loss there. The first sentence of the opinion talks about the fact that there's a CFA violation and there's a loss. The court was grappling with how to determine the replacement value of this carpet that everyone agreed was a loss to the customer. As you said in your opening statement, the plaintiff summary judgment was granted in favor of the plaintiff in this case. These are completely 2 different cases.
Justice Pierre-Louis, while I understand your Honor's position, the tenet that a price on a price tag for setting the value of a product is universal in any consumer fraud act case due to first. And several cases have cited first.
I didn't understand what you
I
just said.
said that the presumption and the holding that a representative price on a price tag by any defendant of a product is its market value is a holding that has much far more reaching application than just in a defective carpet case, because it makes sense when you think about it. Think about when a seller sells any product as the starting point as to value. And that makes sense because they are objectively able to best say what that price is. And that's in terms of evaluating damages. If the court were to, even if the court were to say, okay, well, benefit of the bargain damage, we're not going to apply that here, and we're also not going to apply any damage or any ascertainable loss that's not even out of pocket, then an action where a defendant such as here can knowingly, and this is not some innocent mistake as you see sometimes that some defendants make in Consumer Fraud Act violation cases. This is a knowing intent to list a fictitious price, a regular price, to tell the consumer this is what we're basing our sales on to induce them to buy.
So if this defendant, I'm sorry.
Are you arguing that in first, if they had sold the carpet and it was not defective and it was of the size represented, they still would have been entitled to damages because it was marked down?
Absolutely not.
And isn't that exactly our case, the absolutely not case?
No, because if they would have said the carpet was a regular price of $5,775, and that was a lie, that they never sold it for that value, then that is the Consumer Fraud Act violation. That's not what was at issue.
Why does it say that in first?
The quote in first says, and I'll cite the quote in first says, and this is on page 20, we are mindful that misleading advertising is a deceptive practice. It is a deceptive practice under the Act for a retailer to artificially inflate price for an item of merchandise for the purpose of advertising the item at a large reduction. That is a Consumer Fraud Act violation. And that's 13:45A. And the difference here is, a ruling in this case does not open the floodgates to litigation because there's one simple remedy. The defendant simply tell the truth as to the pricing.
So if the defendants in this case had for one day, okay, new products, January 1st comes around, and for one day they put out there, all of these products are sold at the regular price, the higher of the two prices, not on the sale price today. This is today.
Well,
let me just finish.
Oh, sorry.
And then January 2nd comes around and they are back to the discount. Did you have a claim?
Justice Patterson, not with one day, yes. But the federal regulations and the pricing regs say it has to be offered at its original price or regular price 28 of the last 90 days. Under federal law, it says a reasonable period of time. I would submit if they sold it for
tell us what federal law you're talking about. Is that part of your claim?
Yeah, it's federal regulation 2331, CFR 2331. And it says a reasonable period of time. And I would submit if defendants sold it for a reasonable period of time, even a week or two, this claim would not be here. And talking about the comparative pricing that Mr. Jacobson discussed, there are retailers that put compare at pricing. I mean, you have to understand, Your Honors, the defendants put 50 to 70% in their store. They then have a slash through the regular price. Now this price. They're intentionally conveying to the consumer, this was the original purchase price, and now you're getting a deal. If this wouldn't be a case if they just sold it for their real price for some reasonable period of time. There would be. That's why there's not floodgates of litigation. There's not going to be a case if somebody says, "I bought this sweatshirt. I think it's worth X." If defendants didn't tell them it was worth X, there's no case. There's no violation of the pricing reg. We're here because
when someone says the regular price is X, they're not saying that's the ultimate market worth. I mean, economics, college level economics, the supply and demand, and the price can be, where that supply and the demand curve meets can be very different on a given day or in a different place.
Respectfully, Justice Patterson, this is where I go back to first, because first goes into why the price tag is, for a starting point, and it creates a presumption. It's rebuttable, but it creates a presumption because it recognizes, this court recognized.
But that's all after the court found a violation based on the defective nature of the product. And then the inquiry is, under the UCC, is what is going to make this plaintiff whole? I
understand that, Justice Patterson, but however, when you read first, it's not that narrow. It talks about how just to determine value, and it talks about sellers are in the best position since consumers don't have the same access that a merchant does as to their own products. The consumer's not in nearly as good a position to determine what the value is. So it says, as a starting point, the price on the price tag is market value. It's a rebuttable presumption. The defendant can come in this case, if this case were to go forward, the defendant could come in and say, no, Mr. Denitis, no plaintiff, you have this all wrong. They could present evidence why that is the market value. Like, the market value is not $60 that they've represented, it's less. If they want to point to competitors, which we submit, this case is unique in that they only sell Aeropostale products. So it's not as easy for them to point to what a competitor's price is, but they could rebut that presumption that Justice Patterson is referring to. They could rebut that presumption at trial. They could do discovery. They could say, no, you have it wrong. What Miss Robey bought, it is worth the hoodie is worth $24.95. Or Miss Reynolds, no, your pants are worth $18.95, and they could rebut that presumption. But for a starting point for evaluating damages, the court looked, and then Robey and other cases that followed Robey.
All of that followed the court's finding that it's a deceptive practice for a merchant to deliver household furnishings that are damaged and that are not the exact size, color, or condition indicated in the sales contract, et cetera, under the regulations that applied there that have nothing to do with this. All of that that's the claim. What's the measure of damages is what followed. But the entire discussion was about a consumer who went out and bought a product that turned out to be something entirely different and much less valuable than what was advertised.
Well, and I'll address that, Justice Patterson, in this way. Honestly, I respectfully disagree, but I'll tell you why in terms of the policy that I would support if plaintiff's position is wrong. First, benefit of the barring and damages are not limited to just that one type of violation of the Consumer Fraud Act. It's an available means and a variable nature of an ascertainable loss in any Consumer Fraud Act violation case. But if first is determined as narrow as Justice Patterson is suggesting, then if there is absolutely no ascertainable loss found here, then it would give the green light for any defendant, any seller of merchandise in the state of New Jersey to virtually list any product for any price it wishes to sell it for, fake.
Well, why is that true? Doesn't the Attorney General have the right to enforce the act regardless of whether or not there's an ascertainable loss?
The Attorney General does, but Governor Cahill amended the New Jersey Consumer Fraud Act almost 25 years ago to enable and empower private rights of actions for private attorney generals.
If there's an ascertainable loss. If there's no ascertainable loss, then the Attorney General has the ability to remedy this scenario. If there's no ascertainable loss, there's no private right of action.
Correct, Your Honor, Justice Pierre-Louis. If there's no ascertainable loss, there is no private right of action, and that helps police frivolous claims. But the point is, a private attorney general citizen cannot bring a cause of action if there's no ascertainable loss here.
If you were right that these regulations, read together, read separately, bar the conduct that is at issue here, the Attorney General can take action tomorrow.
That's absolutely
and end it. That's clarified to all of the retailers in New Jersey that this is not this is a violation of the Consumer Fraud Act. The offensive practice that you were talking about here would be over, or else people are in peril of very significant penalties.
Well, Justice Patterson, there are already regs that prohibit this conduct. There are regs that prohibit sellers from doing this. They're the regs that were cited in our papers, and that's part of the basis of this claim. Part of the reason why the law enables private attorney general actions is because the attorney general, and the attorney general is amicus today, and you'll hear from them as well, the court will hear from them, but they don't have the ability to pursue every fraud case. That's why the governor amended the Consumer Fraud Act. And if there's no ascertainable law.
Legislature would have been the ones to amend it. I mean, obviously the governor signed it as.
Correct. I'm sorry. Correct. You're right, Justice Patterson. But I mean, either way, the law now permits private rights of action.
Can you respond to Mr. Jacobson, the Chamber of Commerce argument about Section 9.8?
Yes, that's talking about compare at value.
I'm sorry?
It's comparable pricing. What are competitors selling? They could refer to the competitors' pricing as a basis for that. I have a couple of responses to that. First, the defendants have not maintained that as a defense in this action. Number one. Number two, factually, that's a difficult. That regulation doesn't necessarily apply because Aeropostale only sells Aeropostale products. Other retailers do not. Third, if Aeropostale wishes to come in as a defense and say, no, we do have a basis for selling it at this regular price. Other retailers sell that exact type of sweatshirt or the exact type of pants for the same price, and we're going to permit you to use that as an affirmative defense, and that's how they could rebut the presumption. And so that would be my response. And I don't think it takes the place of still an absolute fabricated fictitious price.
Counsel, doesn't that ignore a little bit of the reality of what's happening here? If I'm not mistaken, this is a store that doesn't have freestanding brick and mortar. They're only in malls usually, right next to other stores that sell the exact same items. 20 of them right down the aisle. They all sell jeans and sweaters and T-shirts and the same items, even though they have different labels for each one. So a consumer can go through each one and say, I've seen 10 pairs of $60 jeans. And this one store has what feel like a similar quality jean for less.
Justice Noriega, that point somewhat highlights why, just to remind the court, we're at the motion to dismiss stage, okay? Defendants represent their Aeropostale products are of unique quality, are special, are different than what other retailers offer. They're better than what other retailers offer. Certainly that could be a defense that Aeropostale could bring in opposition to this case, absolutely. But to determine at the motion to dismiss stage that plaintiff is precluded when it's only Aeropostale products that are at issue. This isn't some, in doing this case, if it was just a basic run-of-the-mill T-shirt that wasn't of special Aeropostale brand, this case may have not have been brought. The thing that's unique about this case is Aeropostale only sells Aeropostale products.
But isn't it common? I don't know the answer to this. Isn't it common in the clothing industry that the same factory produces the same clothes and people are branding them and saying this is mine is better because you get our label along with that clothing?
That's true, but Justice Patterson, and it's not just. I want to clarify something in the record that goes to your point, Justice Patterson. This isn't something unique to New Jersey. There's been several cases around the country. One is Honojos versus California, Honojos versus Kohl's. And in that case, the Ninth Circuit said price matters. It's as important a representative characteristic as anything else about a product. And just in common sense layperson's terms, if you think about that, that makes sense. When a person goes to buy something, they look at, okay, I like that car, or I like that suit, or I like those pants. How much does it cost? Oh, well, that's the price. That's too much. But if it's on sale, wow, I'm getting a deal. I'm going to buy that. And that takes into account that price is as important a quality about anything else. To an example,
do you have a case anywhere outside of New Jersey that deals with a comparable situation to this, not a general statement that price is important, but a comparable statement to this? And which is that?
So several cases. So in Clark versus Eddie Bauer, the Oregon Supreme Court, and that's cited. It came down by the Oregon Supreme Court. It is cited in our table of contents. It's Clark versus Bauer. Supreme Court of Oregon addressed the identical facts as in this case, and held that And that was at the pleading stage, and that plaintiffs have pled an ascertainable loss. In Hennessy versus Cole, Eastern District of Missouri, February 2021, identical allegations and conduct alleged as here. Identical.
Are there contrary cases?
Well, I was going to tell there's several cases before. So there's Missouri, and that's under the Missouri UTPA. Nemenchina versus Old Navy, 461 Fed Sup 3rd, 1054. Identical allegations and conduct here. Court found that it satisfies a claim as pleading ascertainable loss under the Washington Consumer Protection Act. In California, Munning versus Gatt, in the court, Northern District, California, there was claims of under New Jersey law and California law in that case. Court found not only were the California statute at the pleading stage was an ascertainable loss properly pled, but so was a New Jersey Consumer Fraud Act case that in identical, these are called false reference price cases or fake sale cases. So New Jersey is not alone if this court were to find that there is an ascertainable loss here. The First Circuit admittedly finds, as the defendants have articulated, that there is no harm when someone buys something that they know is on sale. They support what defendants are advocating, that look, it doesn't matter what it was originally priced for. Person's told this is the price and they elected to buy it, there's no damage. And also New York followed that. However, I think that, respectfully, and as the courts I mentioned that follow that there is an ascertainable loss, at least at the pleading stage here, it makes sense because if you...
The First Circuit's not the only case that says that. Is that right?
No, it's First Circuit, Second Circuit. I believe they're the two. There's multiple cases in those circuits, but they're the two circuits. And so, I think it's bad policy if there's no ascertainable loss here. It's bad policy to allow a defendant to lie about the price tag to base its sale. When this is not onerous for a defendant to avoid. They just simply have to be honest and just list what the price is for some reasonable period of time that they're selling it for. This isn't some honest mistake as well. This isn't a situation where someone internally made a little mistake and I didn't comply with the Consumer Fraud Act here. This was, if our allegations, which we are taken as true for this hearing, but we believe are true, obviously, because we've tracked their pricing histories, they made a calculated decision to lie to the public. Why is that good in any state? Why is that a good business practice that if there's no ascertainable losses found here, that endorses defendants to say whatever they want about price here?
Do you think there is a regulation on point?
Yeah.
A state regulation on point?
State, yes, Your Honor.
You tell us what that is.
It's the direct one is 34:45A-9.6A, which prohibits a retailer from basing its sale off of fictitious pricing, basing its discounts off of. It's illegal for a seller to base its sale off of fictitious pricing. And this goes back to, and Justice Patterson, I know you did, and Justice Pierre-Louis, I know you disagree with me, but this goes back to why I say First is so important. Because First spends 3.5 to 4 pages of its decision going into a deep dive of the pricing regs and why there's fictitious pricing regs that there's regs that say fictitious sales are illegal and why they're illegal, and they give the policy behind it. And that's why when you read those 4 pages in the opinion and the deep dive that the court goes into there, that's why, and that's part of the reason why the court said in that case that a price on a price tag creates a presumption, because the law says it can't be fictitious. And that's market value. And that's why I say if
you're relying on 96, because you have a Tickman claim as well as
correct,
CFA claim. So
yes.
You have the obligation to show a clearly established right.
Yes.
And so what you're citing to us is 9.6A. And 9.6 defines fictitious former prices as one that a seller cannot substantiate, who's showing prices at which substantial sales of the product or a comparable product were made in the same trade area within 60 days before or after, prices at which the seller offered the product for 28 of the previous 30 or 90 days, and prices that do not exceed the supplier cost plus the usual markup used by the seller in selling a product or comparable prices. Correct?
Yes.
Okay. So does 9.8B's exception for $100 or less prices apply to 9.6A? 9.8B?
It does, Your Honor, in this. If it's a price tag over $100, the defendant then has to give more information to the consumer as to what's the discount based on. If it's under $100, it doesn't. But that doesn't.
My question's really simple. Does the qualifications and that $100 or less limitation of 9.8B apply to what you say is the core regulatory provision that you're relying on, 9.6A?
But the answer to that question, Justice Powers, is it applies, but it doesn't substitute if it is a fictitious price. It doesn't excuse a defendant from still utilizing an existing fictitious price. And I think Your Honor asked my adversary the question like, well, so would that substitute the basis for the price? And counsel said no, and I agree with that. So certainly it doesn't have to be disclosed, but it doesn't excuse or waive a seller's ability to just use a fictitious price just because there's that section of the reg. A couple other closing points, Your Honors. Under TICWNA, under Spade, the court made clear in its opinion that this court made clear that a violation of a New Jersey Administrative Code reg is a violation of a clear established right to serve as purposes of a TICWNA violation. What really turns on in this case, and where the argument has been more so than that, has been, would someone be an aggrieved consumer? I have a couple of responses to that. The first response is if the court were to find an ascertainable loss, whether benefit of the bargain or out of pocket, then certainly an ascertainable loss satisfies an aggrieved consumer standard. Aggrieved consumer is more broad than an actual out of pocket loss. So that's an easy.
How about the converse?
So the converse is it's unsettled. And I get the question would be,
Let me be a little bit clearer. If there is no CFA violation, can your client be an aggrieved consumer, given that we're talking about a transactional situation?
I understand. So this court, I think they're more of an aggrieved consumer than they were in Spade for not getting in Spade, there was a clause in a contract that they did not, that said if you don't get your furniture on time, you can't seek a refund, and that contravened what a New Jersey regulation said. But the plaintiff there the furniture didn't come late. So yeah, it was illegal in the clause in the contract, but they weren't aggrieved in any way. Here, this isn't subjective disappointment. These people are clearly not getting what they want. So I think if you look at Spade, you can make a very good argument that when you look at Spade and you look about, the court went into the definition of what's aggrieved, what's an aggrieved person, someone that's experiencing grief, looked at Black's dictionary.
You're asking us to, if it gets to this point, to find that an aggrieved consumer is a person who has suffered no loss.
Well, I wouldn't say Chief Justice
Rabner. But isn't that an essence?
I would say no loss.
That's what you're asking.
But I'm asking, would that give rise to an aggrieved consumer? Well, certainly what these people are claiming they experienced here.
Be an aggrieved consumer without having suffered a loss is in essence the argument you're advancing.
That would be, I would certainly hope it doesn't get to that point, Your Honors, but I would articulate and argue that yes, even if the court were not to find an ascertainable loss here, these people would be aggrieved because they're not getting what they were promised.
But they received the sweatshirt that they paid for and kept the sweatshirt and apparently anticipate continuing to shop at this same store where they are apparently not getting what they asked for. I'm having trouble understanding that argument because that's correct. Your clients will continue to shop at Aeropostale. and intend to do so, intend to keep the clothes that they purchase, are not making the argument that the $24 sweatshirt was worth less than $24. You are conceding that it's worth $24. Your clients paid $24. Your clients have kept will keep the sweatshirt and will continue shopping there. So what is aggrieved in that scenario? That subjective feeling that your clients didn't get this bargain that they hoped for, notwithstanding the fact that they appear to be pretty satisfied and happy with the clothes that they are continuing to purchase.
Justice Pierre-Louis, respectfully, this isn't a subjective feeling of loss. This is based on what they were promised. So, and it's a slippery slope. So if the price doesn't matter, if a defendant could say, we're selling this for 60, but that's not true, but you're still knowingly paying this price. At what point where does a court draw a line?
We don't draw the line. We don't draw the line. The legislature drew the line. Why do you suppose they said for a consumer to be aggrieved, they have to have an ascertainable loss? But the AG, if they do this unconscionable, immoral thing you're talking about, can stop them, can get an injunction, can get penalties, fines. Why do you suppose the legislature made that distinction?
Well, the legislature, Justice Solomon, they've broadened it to allow private citizens to bring private rights of actions because the Attorney General
They can prove ascertainable loss. However, they didn't say the AG had to prove that. The AG's out there enforcing our laws and regulations with the ability to do all the things you're talking about if this horrific, unconscionable, immoral retailer is doing what you're suggesting. Why do you suppose the legislature didn't require the AG to prove ascertainable loss, but did require the consumer to prove ascertainable loss? Certainly, Justice Solomon, certainly ascertainable loss is a gatekeeper function to not just let anybody file any claim whenever they want. Unless they're the AG. Unless they're the AG. However, not finding an ascertainable loss here, which is again solely based on defendants' conduct in having to lie to increase their sales or to create revenue. Why is that good policy if there is no ascertainable loss? That's not our call. We don't make that kind of policy. The legislature already made it. They passed the law, the entity and state government passed the regulations. Well, Justice Solomon, the legislature, when they passed the Consumer Fraud Act, they said ascertainable loss. They didn't say loss of monies specifically. That's broader than that. And the courts have found numerous other avenues where courts have interpreted what ascertainable loss means, because the legislature just says ascertainable loss.
I have one quick question. I don't want to cut you off. Are you through with your answer?
Well, I was just going to say there's repair costs, diminution of value. There's a lot of different ways to look at ascertainable loss. We're saying that our people did not get the benefit of the bargain. They didn't get what they were promised.
They say you cannot use out of pocket either, in part because your clients retain value. They never attempted to return the goods. How do you respond to that?
Well, under Boslin versus Warnock, it's pretty well settled law that to bring a Consumer Fraud Act violation claim, you do not need to return the product. Okay, and in a lot of cases that we see, Romano versus Galaxy Toyota, in first and other cases that are cited in the papers, people do not have to return the product and able to bring an ascertainable loss claim under the Consumer Fraud Act. So that's pretty well settled. Here, plaintiff feels there should be some ascertainable loss. We pled both theories in our complaint because at the motion to dismiss stage early in the case, there's case law under Perkins versus Chrysler that you actually don't really need to delineate the nature at this early stage in the litigation.
But out-of-pocket losses are about the difference between the price paid and the actual value. And you say that I don't want to misquote this, but what if the jeans are worth $16 because that they paid? I mean, that's a concession there. So if that's the definition and under a number of different cases of what out-of-pocket loss, how can you possibly prove an out-of-pocket loss?
It can apply, Justice Patterson, in that we allege in our complaint also that these people wouldn't have purchased but for the sale price.
So you're looking for a full refund.
So that would be one avenue of damages. I think it's best for a jury to hear both and apply whatever is most equitable, listening to the facts.
You're looking for a full refund and they've got the clothing, and the clothing is not defective, and they're wearing the clothing, and you want a refund trebled.
Under the Consumer Fraud Act, if a consumer violation is found, yes. If a jury were to find that the Consumer Fraud Act was violated, because in this case, there was a scheme, a system-wide scheme of lying about all the products as to what the products cost deliberately, and the jury found that was violated, that should be one avenue worth the damages. Certainly, defendants could argue.
I think we have your position, counsel. I wanted to ask you to try to wrap up your argument.
Oh, thank you, Your Honor. So, Chief Justice. So, as we've stated, it's plaintiff's contention that this is well settled under this court's prior precedent. We also think that policy dictates that good policy would be to find that there's an ascertainable loss, a benefit of the bargain, or an out-of-pocket. The nature at this early stage does not have to be drawn a line in the sand, but to allow no ascertainable loss here would really permit the only enforceable body to enforce any type of fraud would be the Attorney General, which under case law, courts have viewed that they are not equipped to handle every fraud that's imaginable and be enforced.
Let's hear
and so
what they
for
have to
those
say
reasons,
now.
we would
Very
submit.
well.
Thank you.
Thank you. Ms. Hanley.
May it please the court. You've heard SPARC argue this morning that it can entirely evade direct liability to consumers for a pernicious and lucrative form of fraud, lying about its products' regular prices to trick consumers into believing that its products are worth more than they are. Because this fraudulent practice violates the CFA, but public enforcement resources are limited, the Attorney General has an interest in ensuring that the CFA's private cause of action is properly construed to authorize claims like this one. In line with that interest, the Attorney General is here as amicus curiae to explain why plaintiffs have standing to litigate their claim for damages and injunctive relief. In short, plaintiffs have standing because SPARC's fraudulent ads caused them to expect that they were purchasing an item of greater value than the item's actual worth, depriving them of the benefit.
Is it a standing issue? I'm just wondering why you're saying it's an issue of standing. It's really, isn't it, under the CFA, an issue, an element of their substantive claim to have an ascertainable loss? It's not. I don't see that as a standing issue. Am I incorrect about that?
This court has called it a standing issue in Weinberg. It has referred to the ascertainable loss requirement as a standing requirement. And I think that's just to distinguish between a substantive CFA violation and what the CFA's private cause of action, which is particular to private plaintiffs bringing suits, the difference, which everyone is well aware of, between the lawsuits that the Attorney General can bring and those that private plaintiffs can bring. However, you're completely right, Justice Patterson, that it's also frequently ticked off as one of the elements. You need a CFA violation, you need ascertainable loss.
In the statute, it's an element.
What you have is NJSA 56-8-19, which just states that that section is the private cause of action. So it's what enables private plaintiffs to come into court. And that it's sort of the elements of the private cause of action. In that sense, it's the statutory standing provision, and it allows private plaintiffs to come into court when there has been a CFA violation that they personally have been a victim of and have suffered loss from. Given how argument has gone this morning, I want to primarily address this objective-subjective distinction. And I would note that, SPARC's position is that it is idiosyncratic and subjective to believe that an item that was previously and hopefully legitimately and honestly offered for sale on the market for $60 is not of greater value than an item that was previously and legitimately offered for sale for $24. And we would submit that that's actually the simplest and most straightforward misrepresentation of value. In other cases, when you're in a position of determining whether what was promised is objectively more valuable than what was received, you would take the sort of characteristic at issue and you would ask, what does that normally sell for on the market? And does that sell for more than what was actually received sells for? So for example, if you take the Campbell soup case, that was a case in which there was a fraudulent misrepresentation that the soup had 25% less sodium, when in actuality it did not. It had the regular amount of sodium. And SPARC doesn't dispute that there was a loss there. And so its position seems to be that there's something objectively valid about thinking 25% reduced sodium soup is more valuable than regular sodium soup, but there's not something objectively valid about thinking that an item that regularly sells for $60 is worth more than an item that regularly sells for $24. And we would submit that the item that regularly sells for $60 being worth more than the item that regularly sells for $24 is just a simpler case. Yes, Justice.
Price is different than construct and content. I mean, in one case, the stuff in the soup wasn't what they said it was. In this case, the stuff in the sweatshirt is exactly what they said it was. That's the difference. Price does not set value. Price is never synonymous with value. In a marketplace, it's just not. It's not the definition.
So the item that the amount that an item regularly sells for on the market is the best indicator of value.
But that's not what the price tag is. The price tag is not it's whatever the seller wants to sell it at, whatever the consumer is willing to buy it at, regardless of what that number is. Price does not equal value. It never does. It's the same reason that, I don't mean to use third terms of Justice Patterson, but Gucci shoes are worth more.
I knew it'd make me look bad.
I'm sorry. Gucci shoes are worth more than the identical shoe without Gucci's name on them.
Right. And the way we know that is we look at what Gucci shoes regularly sell for on the market. That's always the ultimate thing we look for, because
No, that actually is not. What the willing consumer will pay and what the willing buyer will accept. It's not what's sold, and it can go in the market at $1,000 a shoe, which would be $2,000 a pair. You're not math students. But that may sell zero. That price has no comparison to value. It never does.
I think our point is that if you only know two items appear to be the same, and what you know about them, just assume that it is actually true that one regularly sells for $60 and one regularly sells for $24. We would submit that it would actually be irrational to prefer and assign greater worth to the one that regularly sells for $24. If that's the only difference you can observe between the two, the one that regularly sells for $60 is worth more. And again, just to go back to the soup example, what the District of New Jersey accepted there, and that SPARC doesn't dispute was a right way to proceed, they said, what is the 25% reduced sodium soup regularly offered for sale at? And they observed that that is more than what regular sodium soup is offered for sale at. And they observed that the difference is the loss. And here you basically skip a step. All you have to say is, what is a sweatshirt that regularly sells for $60 regularly sold at? $60. And what is a sweatshirt that is regularly sold for $24 regularly sold for $24? And you can see that there is a loss there. So
what is the Attorney General's position regarding the import of Section 9.8B?
Sure. So I would just note that SPARC did not petition for certification on whether there was a CFA violation here, but we believe that the appellate division was correct in understanding that a violation of 1345A-9.6A was properly alleged. I think there's been a little bit of confusion this morning about.
But we have a Tickman violation alleged here, and that requires a clearly established right. So it is, respectfully, I think it is important for us to understand what the AG's position is with respect to, I say, and I'm looking at your brief at page 6, you say, regulations promulgated by the division specify that the use of a fictitious formal price violates the CFA. You cite 9.6A and then a C also to 9.6D. But what is the position of the AG regarding 9.8B?
Yes. 9.8B exempts from the requirements of 9.5 that you expressly disclose the basis, like what the reference price refers to. And so there's no requirement. Aeropostale did not have to say specifically what the reference price referred to. So it's exempted from 9.5. However, that part of 9.8, which exempts items worth less than $100 from the requirements of 9.5, does not refer to 9.6.
So does section 9.8 have any impact on 9.6?
No, it does not.
And where is how do we know that? Or more appropriately, how do the defendants know that, since the Tickman allegation requires a violation of a clearly established right?
So 9.8 expressly refers to 9.5. So it just says you aren't required to comply with basically the affirmative disclosure requirements of 9.5. That's just what 9.8 says. And it doesn't encompass 9.6. And we would also note that, and we have no position on the Tickman claim. The Attorney General doesn't enforce it. But you could also look at 9.2A, which is the sort of general prohibition on fraudulent pricing advertisements, as well as simply the broad prohibition of the CFA 56.8-2, which prohibits just fraudulent practices generally.
Has the Attorney General enjoined any conduct such as the conduct that it is coming before the court and saying is a violation of the CFA?
I'm not aware that it has. These matters usually settle, but I can't represent either way. But we certainly are here in support of respondents because there are simply too many of these violations for our office to be able to prosecute all of them. It takes significant investigative work.
But you are here saying to us there is a current, as we speak, unlawful practice going on in the retail industry in New Jersey because of this type of pricing.
If the allegations are accepted as true, we haven't done the investigative work.
I'm not saying this particular case, but you are here saying to us that if consumers out there in the clothing industry or the food industry or whatever it may be are putting reference prices on their price tags that they have not actually sold the product for, that is a violation of the regulations.
There's slightly more nuance than that, which is spelled out in 9.6b, but if there is in fact essentially no basis for the former price, which is what is alleged here, then yes, that would be CFA.
And 9.6b says percentage off discounts that are subject to 9.8, and here again that brings
that's 9.5. So
well, I thought B says percentage off discounts. I'm reading from one of the amicus briefs. Made in accordance with NJCJI 9.8 shall be exempt from the requirements of A above. That's what B says.
So 9.6b is.
Oh, I'm sorry. You're right. 9.5. I apologize.
The structure of 9.6b is part A simply says it shall be a violation of the consumer product to use a fictitious former price. And then 9.6b lays out the ways that a seller can substantiate its former prices. And there are 3 different ways. And they're quite flexible. I think they really are designed to capture whatever a bona fide former price would be. And so, again, because SPARC didn't petition for certification on whether there was a CFA violation, the Attorney General is mainly here today to say, when you have a violation of 9.6a, private plaintiffs can prosecute that because there is an ascertainable loss. And I just want to speak a little bit about first and just clarify to the extent to which we're using first. We certainly understand that first is in a different procedural posture. And so our position is not that we say it's first and that's the end of the day. It certainly takes more work than that. We do think it's the most on-point case, but we agree that this court is just sort of needs to decide this issue on first principles and in line with the CFA's remedial purpose. But first does establish two things very clearly. One is its statement that benefit of the bargain damages are an available theory for conceptualizing ascertainable loss. And benefit of the bargain damages are designed to put the defrauded consumer in the position they would have been in had the misrepresentations been true. And so I'd like to use the Cox case as an example because I think it responds to some of Justice Pierre-Louis' concerns about maybe a concern that you're in a better position that you would have been in, so there wasn't a loss. But benefit of the bargain damages put you in, again, in the position you would have been in had the misrepresentation been true. They don't ask for a comparison between what you got and what you paid. They ask what were you promised and what did you get. So in the Cox case, you had, again, a different CFA violation. It's not similar in that sense. But there, the defendant promised to repair the plaintiff's kitchen, and they failed to do so adequately. But importantly, the plaintiff never paid anything for the kitchen repair. Contract price was something like $8,000. They never paid for the repairs. The repairs were poorly done. At the end of the day, the court said that the plaintiff didn't have to pay anything. They hadn't paid. They didn't need to pay anything. In addition to that, they received the money they would need to repair the kitchen. So the point of the damages award was to put the plaintiff in the position they would have been in had this CFA violation not occurred, which means they needed the money to repair the kitchen. So I just say that because if it were the case that the plaintiff couldn't end up with greater money than what their output was, Cox would have come out differently because they paid out nothing.
But respectfully, Cox is very different because in Cox, the kitchen was unusable when the defendants were through with it. They had to start from well before scratch. They had to repair a defective job that was done that costed additional out-of-pocket money. I think the only analogy to that would be somebody coming in saying, this sweatshirt was so driving me insane that I bought this and it really was not worth $60, that I've been suffering psychiatric damages and I've had to have treatment. I mean, that's really the only analogy. And I think Cox is a stretch, respectfully.
So Justice Patterson, if you look at the damages in Cox, I actually think that doesn't play out because the contract price was about $8,000, and the court actually determined that some small amount of money was owed to Sears, was the person who, the company there. Some small amount of money was actually owed to Sears for the value of the repairs that had been done. And then they additionally awarded the plaintiff the money that would need to do the kitchen repairs. I think it's a little confusing there because the word repair is being used, but before any of this happened, the plaintiff was trying to repair the kitchen. It had faulty wiring, it had all these issues, it needed to repair them. The Sears did all this work that was basically useless. And a little worse than useless. Again, as described in the opinion. That's not, sorry. What the court determined is actually it had a little bit of value. It net had a little bit of value for the plaintiff because they said it was, I think, $358 was actually owed to Sears for the value of the repairs. And nonetheless, they still awarded about $6,000 to the plaintiff so that the kitchen could be repaired. And again, the plaintiff never paid out a penny there.
Counsel, in the interest of time, since we're a little bit beyond the 5 minutes, do you want to tell us what your core principle in Cox is and then wrap up your argument, please?
Sure. So the point from Cox is just that there's no windfall problem here. and that benefit of the bargain damages are not just concerned with whether what you paid is worth what you got, but whether how to put you in the position you would have been in had there been no CFA violation. So had the misrepresentations been true here.
But isn't there some inconsistency with saying that consumers value intangible qualities like past value and getting a bargain, but then in the same breath saying, but it's not actually an intangible quality, there is an exact way to calculate it, and that's 60 minus 24. The 60 minus 24 valuation, which I think is what you're arguing in terms of benefit of the bargain, if we're talking about a sweatshirt that was originally listed at 60 and someone paid 24, that would make sense to me if the person paid 60 and it turned out it was only worth 24. Then 60 minus 24 is the difference. Here, though, they're alleging that they paid 24 and that it was worth 24. And then you're alleging that there was something intangible, that they only paid the 24 because really to them it was worth something intangible, that they were getting a bargain. But then you're also saying that the way to calculate that intangible value is 60 minus 24, even though they paid 24 and they agree that they got something worth 24. How do you reconcile that?
Sure, Justice Weiner after. So I think you're speaking in part about the out-of-pocket loss theory, which does ask for a comparison between what you paid and what you got. But we're advancing a benefit of the bargain theory, which doesn't compare what you paid with what you got. It compares the value you were promised with the value you received. So our position is that the value you were promised a $60 sweatshirt, you got a $24 sweatshirt. So that's the difference. On the intangible piece.
But isn't the benefit of the bargain supposed to put the person back in the position as you were just explaining, where they would have been but for the misrepresentation that's being alleged here?
That's right.
So wouldn't they have not even walked into that store if they and certainly not bought the sweatshirt, the now famous sweatshirt? So where they would be, but for this alleged misrepresentation, is they just kept walking and they didn't buy this sweatshirt. They didn't have a sweatshirt, and they didn't spend the $20 that they spent to whatever it was to get the sweatshirt. Why isn't that the benefit of the bargain?
So I think the benefit of the bargain in fraud cases is put the plaintiff in the position they would have been in had the misrepresentation been true, not had the misrepresentation not happened. So it's if you were promised a sweatshirt that SPARC in fact would have regularly sold on the market for $60, then it's trying to put you in the position you would have been in if that fact were true, not if that misrepresentation had never been made.
But it's more than that, because it's not selling for $60. It's selling for $24 or whatever it may be. So the position that you would have been in if it had really been a $60 prior sale, prior price that was actually enforced, depends on all kinds of subjective factors that are going on in the mind of the consumer. I mean, I think you're making it a measurable damage when in fact it's a really difficult damage to measure.
So I would invoke the first presumption, but simply for the fact that the court there remarked that both because it makes sense as a matter of economics and because there are good public policy reasons for presuming that the regular price on a sticker tag represents the fair market value of the item. So SPARC essentially represented that the fair market value was $60.
But first, I think you'd concede, comes out of the UCC's remedy for defective products.
So the CFA violation in first was different. CFA violation in first was a failure to deliver conforming goods. And there, it was purely about damages. The CFA violation, there was already summary judgment on that issue. So we are in a very different procedural posture. But first is clear that, and this is at 182 NJ 17, sales promise the regular value of a product at a reduced price. When honest and legitimate, the regular price must bear some relationship to what the retailer considered to be the market value of the merchandise in the recent regular course of business. So we would argue that that sort of reasoning, especially in considering the CFA's remedial purpose, is directly on point here. But again, we do acknowledge that first was about damages, and here we're talking about ascertainable loss. However, this court has previously acknowledged that if you could get damages, there would be an ascertainable loss, but we are at a different stage of the litigation here.
And a defective product versus a product with no defect. You would concede that's a very material factor here, is it? Wouldn't you?
I don't think that is a difference that goes to ascertainable loss. That is a difference that goes to what CFA violation was at issue. So here, the CFA violation is a violation of the fictitious former pricing regulations, 1345A 9.6A. Whereas there, it was just a different regulation, and that regulation required providing conforming goods when they were originally not provided. But again, we would just say that first clearly articulates that a benefit of the bargain conception of loss is cognizable under the CFA. And again, that just asks, put the plaintiff in the position they would have been in had the misrepresentation been true. In first, the CFA violation wasn't a misrepresentation. It was just a failure to deliver the conforming goods, so it was a little bit different. It would be put the plaintiff in the position they would have been in had they gotten the conforming goods. But here, it's put the plaintiff in the position they would have been in had the misrepresentation in violation of the fictitious foreign pricing regulations been true.
Ms. Hanley, I'm sorry to stop your argument at this point. We appreciate your help.
Thank you so much.
Placitella, the gift of going last is you can adopt arguments that have already been advanced. Please go ahead.
Thank you, Your Honor. And thank you for giving NJCJI the opportunity to appear today and argue as a friend of the court. I know a lot has been said today, but I want to address why there's an ascertainable loss here and why the plaintiff should be entitled to seek injunctive relief. Nearly 20 years ago, this court in First acknowledged that one of the central tenets of market psychology is that consumers do not want to pay full price and are always in search of the best deal. That's not something intangible. That is a scientific principle that merchants draw in consumers by holding sales events to promise a regular value of a product at a reduced price. Consumers believe they receive greater value when they are compared with a reference price versus a sale price. As said by the court in First, the consumer surely would not think he is getting a bargain if the product he purchases is worth no more than the price he paid. So when a merchant misrepresents that its product has a premium value, the consumer is not only tricked into buying a product they otherwise would not have, but they're also deprived of the essential benefit of the bargain. This court's teachings that the CFA is to be applied broadly and construed liberally in favor of consumers pertains not only to what is a CFA violation, but also how to apply the statute's ascertainable loss requirement. And I want to hit on this point of the day about the benefit of the bargain theory, because there seems to be much confusion that just because there's no physical defect in the product doesn't mean there can be an ascertainable loss. First, a product does not need to be defective in any way for a plaintiff to maintain a CFA claim. That's a central tenet of the CFA that's even found in the model jury charge 4.43. Second, the CFA cannot be interpreted.
I don't think that's being asserted in any way. It's simply that distinguishes the benefit of the bargain theory coming out of First was about the defective, non-conforming nature of the product. That's the point that at least I was trying to make.
Okay. And second, the CFA can't be interpreted to permit a merchant to profit from its own deception. But under the defendant's interpretation, its conduct would continue unabated and the plaintiffs would have no remedy. I want to discuss two specific New Jersey cases that touch on the principle of a CFA violation occurring even when there is nothing substantively wrong with the product. The first is Miller versus American Publishing. We reference this in our brief. In Thiedman, this court said that Miller is sufficient proof as an ascertainable loss in respect to a lost bargain. So in Miller, the plaintiffs alleged they were defrauded into buying a magazine subscription, as it was suggested they may have an esoteric better chance of winning the defendant's sweepstakes. You didn't have to buy a magazine subscription to enter the sweepstakes, but if you did, the representation was you would have a better chance. That representation was not true. But this court still found there was an ascertainable loss for the benefit of the bargain. There was nothing wrong with the magazine. The plaintiff still enjoyed it, didn't have to return it. But this court explained that when you set out to buy two things and you don't receive two things, then that is a loss for the benefit of the bargain. In Miller, it was that the plaintiff sought to buy the magazine subscription and this esoteric likelihood, enhanced likelihood of winning a sweepstakes. And there, it was the clear example of ascertainable loss. Here, this case is similar. The plaintiff went out to buy a sweatshirt and a bargain. All they got was the sweatshirt.
But in Miller, the subscription was deemed less valuable because there was no increased chance of winning the sweepstakes. Here, there's no allegation that the sweatshirt, again, was less valuable than what the plaintiffs paid for the sweatshirt. The plaintiffs paid $24, and they agree that it's a $24 sweatshirt. And there's no allegation that the fibers were different or less valuable than they intended, or the zippers or the pockets or whatever were of less value. So it's not exactly the same.
Well, I respectfully, I think I disagree. I didn't see that in the reading of Miller. Right? Miller, you had a magazine subscription. The magazine is not any less valuable. Somebody could enter the sweepstakes and have the magazine, or just enter the sweepstakes. It was the fraud and the inducement to get you to buy the magazine was to say, hey, if you buy our magazine, you're going to get a higher chance to win the sweepstakes. That's what drew the plaintiff and Miller to buy the magazine. And there, this court found, Thiedman approved of that decision, and that court found that there was still an ascertainable loss. The other case I wanted to address is Romano. I was touched briefly, Romano for Galaxy, the appellate division. There, the plaintiff alleged she was defrauded when the car dealer misrepresented the value of the vehicle she had purchased because the odometer had been rolled back. Notably, there was nothing wrong with the car, right? It didn't need any type of repair or anything else. The only reason why the plaintiff actually discovered the fraud was because a check engine light went on, which we've all seen in our cars, took it to the shop, and they found that the odometer had been rolled back. Right?
The analogy to that would, in this situation, would be clothing that's actually used. I mean, the odometer is presented. It's presented as a new car. It's not. It's not a new car. It's a car that's got miles on it in Romano. So the analogy to that would be, this is not a new piece of clothing. This is something we've stuck a price tag on that's already been used. That's totally different.
I'm not sure if I follow that, Justice Patterson, because the car Romano was still used. It still had miles on it. They just misrepresented that it had less miles on it than it already did.
But it was the actual inherent car was not what was presented in terms of its value.
Well, the car that was presented was the car that the plaintiff bought for the price that the plaintiff bought it. There was nothing wrong with the car.
Look at the blue book.
Excuse me.
Look at the blue book. The value of a car with more miles is worth less than the value of the car with less miles. So there is an established value that is less than what was paid based upon the representation.
And the established value here, based on the representation, is the price tag that the defendant says, this is what we're going to sell this for.
Sweatshirts. There is no blue book for sweatshirts. A sweatshirt, $24 sweatshirt that's constructed the way a $24 sweatshirt is worth $24. That's it. A car that's got 100,000 miles is worth less than a car that's got 50,000 miles. That's it.
Well, the price that,
I don't want to get back to.
okay, the price I hear that the defendants represent, right? That sets the market.
I think
So
that's
if
bad.
the plaintiff, Robey or Reynolds, wanted to go sell that sweatshirt on a secondary market, like Poshmark, right? They would say that this sweatshirt, as set by the people who make the market, is worth $100 or worth $60, and therefore I could sell it up to 60. Or if it was used, it would be whatever somebody else would buy for in the secondary market.
Is that the value that needs to be looked for here? Is the value of a sweatshirt on the secondary market?
No, I'm just using the example of how you set the market, right? The defendants here set the market. So
I don't know that the example helps. Imagine if it were advertised as a sweatshirt that had been used once when in fact it had been used 500 times. Would you agree there's a difference in those values?
I do, Your Honor. I do think that would make this case more like Romano. And besides the benefit of the bargain theory, here there's a clear case of a purchase price out of pocket, right? So my friend referenced earlier the Clark case out of the Oregon Supreme Court. That's Clark v. Eddie Bauer, 532 P3D 880. And that case was issued a few days after this court granted certification in this case, right? It raises the same issue. Our courts have looked to Oregon's Consumer Fraud Act, their UPTA case, UPTA statute in other cases because our consumer fraud statutes are similar. Both require an ascertainable loss in order for a plaintiff to satisfy their claim and to have standing, and both define ascertainable loss in the same way. And in Oregon, that court explained in these same facts that the consumer sustains an ascertainable economic loss of the purchase price when she has been induced by another person's unlawful activities to pay money for something that the first person would not have otherwise bought. And that tracks with this court's precedent. So for example, in Dugan, 231 NJ at 60, this court said individual plaintiffs may be able to establish ascertainable loss and causation by showing they would not have purchased the beverages had they been informed of their cost. In Cox, 138 NJ at 21, this court references that the ascertainable losses in that case was not the price paid out of pocket because the fraud didn't happen in the contracting. But that's what happened here. The fraud, alleged fraud, happens in the inducement of the reduced sale price that caused the plaintiff to buy the product. And in Clark, the Oregon Supreme Court found those purchase price damages were available even in the absence of a showing that the seller misrepresented some characteristic or quality of the product sold. That's the same as in Dugan. The plaintiffs didn't allege there was anything wrong with the soda. It's the same thing as in Miller. The plaintiff didn't allege there was anything wrong with the magazine.
In Clark, also, was there no attempt by the plaintiff to return the product?
Correct. There was no attempt by the plaintiff to return the product. As my friend said under Bosland, there is no requirement, plain text requirement under the CFA that a plaintiff needs to do so. That's a question for the legislature that it has not addressed. Now, briefly, if there's nothing else on the ascertainable loss, because I know we've been going long on time today, I just want to address the injunctive relief point. Thank you, Your Honor. So the CFA mandates that any action, this court shall, in addition to other equitable, appropriate legal or equitable relief, award damages. And we know from discussion today that in order for a private plaintiff to have standing, and Weinberg and Laufer, the appellate division, refer to the ascertainable loss when it comes to injunctive relief, refer to that element as also a standing element. In order to pursue their own standing for their own class of action, they must present sufficient evidence of an ascertainable loss. And the CFA, as was referred to, was amended in 1971 after 11 years after it was already passed in the books. And if we look at the legislative history, it's sparse, but we look at the governor's statement, one of the specific reasons why it was amended was to provide plaintiffs the power of a private attorney general to enforce and supplement the CFA, to help the attorney general because there was too much fraud for the attorney general to take on its own. SPARC, in its presentation, said that injunctive relief is not appropriate here because there's no threat of future harm and there's no proof that damages are inadequate. And I want to address those 2 points. First, to the threat of future harm. Here, the defendant is SPARC Group LLC. There is no store, brick and mortar store, called SPARC Group, right? SPARC is a company that owns many brands. SPARC was the parent company in the Clark case, and that involved Eddie Bauer. So these same plaintiffs may be deceived by the same conduct by the same defendant under one of its different brands, even if it's not Arrow Pastel. But more importantly, it does not even matter whether the merchant's conduct misled the specific plaintiff. As this court has said repeatedly, it is the capacity to mislead, is that what it's important in itself, that must be remedied through the Consumer Fraud Act. Finally, the power provided as private attorneys general gives the consumer the right to enjoy unlawful conduct on behalf of all other consumers. This was addressed specifically in the Laffer case before the appellate division, where that case explained once the class representative shows they have an ascertainable loss, then they have standing to pursue injunctive relief on behalf of other consumers, on behalf of the class.
So is it your, just out of curiosity, because with your colleague in the AG's office, we're talking about this, is this concept of standing within the injunctive relief portion of the CFA? Yes,
Your Honor. Ascertainable loss is both an element.
As to the damages section, it's an element of the substantive element of the cause of action, correct?
Correct.
You don't hear of standing issues, ascertainable loss being a standing issue with respect to whether there is a claim for damages under the CFA.
That's not in our case law. Where the word of ascertainable loss coming up as a standing requirement is the standing to assert injunctive relief, to get an injunction.
So it is an element of the offense, it's a necessary element of the substantive offense in a cause of action for damages.
Correct. And
sorry, so you're agreeing that a plaintiff cannot get injunctive relief unless they have shown an ascertainable loss?
Correct. I mean, you have to prove that what the case law says, and I think it's important, is that you need to allege a bona fide claim of ascertainable loss in order to have standing to pursue injunctive relief. You don't have to prove that ascertainable loss at trial. You just need to have enough facts to overcome summary judgment. And that makes sense for a few reasons. One, whether equitable relief is available is a question for to be decided by the court and not the jury. And two is if you prove the CFA violation enough to overcome summary judgment, and you have sufficient standing to be there that you've shown enough proof of an ascertainable loss to get to a jury, then the policy would dictate that it would make sense to enjoin the conduct going forward and not have it be dependent on whether the plaintiff a jury finds an ascertainable loss. Now, finally, why damages are not adequate here for injunctive relief, to address that point specifically. The Chamber of Commerce has said its conduct is okay and is mainstream. And as shown in our appendix, the article from the Wall Street Journal and others, the market conditions actually incentivize this practice to continue. It says that retailers will continue to promote such misleading deals since its risk of losing market share is greater than any reputational or monetary damage they may incur from related legal cases. So right now, the market conditions—
Quoting a Wall Street Journal article?
Correct. It's in our appendix, Your Honor. That the market conditions show that if this conduct goes unabated, that it will continue unless this court provides the plaintiffs the ability to stop it if they can prove they have sufficient standing of ascertainable loss to move forward with their claim.
Well, the issue we had before is whether there's the CFA and tech want to provide a remedy. It's really not for us to decide whether it's good or bad policy.
Well, the question presented before, asked by this court, is whether the plaintiff should have the ability to seek injunctive relief. And what we're saying is based on these facts, the plaintiffs should be able to, especially after they get past this gating period.
Thank you, Mr. Plastow.
Thank you, Your Honor.
Mr. Moody. Brief rebuttal, please.
Thank you, Your Honor. Just a couple of points in rebuttal. First of all, to assert an ascertainable loss, there must be a loss. And here, we haven't heard anything suggesting that there's a loss. In our latest brief filed on October 25th, we outlined 3 different worlds. One where a consumer buys a sweatshirt thinking that $60 was a former price, one where the consumer sees the $60 and disregards it, and a third where the consumer sees a $24 price tag. All 3 buy the same sweatshirt, all 3 pay $24. There is no objective difference between any one of those consumers and any other. So here, there has been no loss, and with no loss, there can be no ascertainable cost, no ascertainable loss. Second, plaintiff's counsel asked for a rebuttable presumption that the reference price would be the market value. For all of the reasons that the bench has outlined, first, doesn't provide the rule of decision here. But beyond that, even if the court were to import the rebuttable presumption, it doesn't apply here. Plaintiffs have pled themselves out of it. They allege that the sweatshirt never sold for $60. If it never sold for $60, it cannot be the fair market value. And as first notes, replacement value is fair market value. Third, we've heard some reliance on the Oregon Supreme Court's decision in Clark. The court should not follow Clark. That court interpreted Oregon statute to embrace transaction causation, not to require loss causation. That reads the ascertainable loss element out of the statute.
Can you explain what that means, please?
Certainly. The Oregon Supreme Court said that there is an ascertainable loss because the plaintiffs chose to enter into a transaction because of the violation. Choosing to enter into the transaction does not indicate that there's been a loss. They are separate questions, as the stockbroker example I gave earlier outlines. Reading it as the Oregon Supreme Court did conflates the violation and loss, as the Shawless case outlined in the First Circuit. Another reason not to follow Clark. That was an out-of-pocket loss conclusion. In New Jersey, out-of-pocket loss exists only if the item received is objectively less valuable than the amount paid. And you can get a full refund, as plaintiffs request here, only if the product is essentially worthless. That's a Mladenov case, a federal district court case over store-bought bread. Without alleging that the product is essentially worthless, there's no refund of the purchase price.
So your argument is that Oregon has a different theory of out-of-pocket costs, and that the Oregon case relied on that, Clark?
That's correct, Your Honor. And then third, the Clark case, for its out-of-pocket loss conclusion, did not consider the set-off for a retained value. That is required here. If the court were to indulge in out-of-pocket theory here, it would have to note, or it ought to note, that for a plaintiff to allege an out-of-pocket loss, they must take into consideration, and courts applying that claim must take into consideration the retained value, and there must be a set-off for that retained value.
And as I understand, your argument here is that that since it is conceded that the $24 was the value of the sweatshirt has been retained, there is no out-of-pocket loss.
Exactly, Your Honor. 24 minus 24 is 0. 0 is not greater than 0. Therefore, there's been no ascertainable loss. Additionally, we've heard a lot about policy arguments. This is a court of law, not a court of policy. Even if the court were to consider policy issues, the outcome that plaintiffs request here, I submit, would be bad policy. And for that, I would direct you to the National Retail Federation's amicus brief, specifically pages 14 to 15, noting that former Federal Trade Commissioner Robert Pitofsky
I think we can move beyond.
Fair enough. If I could have a moment to briefly conclude, Your Honor.
Please.
The appellate division's cascading errors in this case all stem from the mistaken conclusion that a consumer can suffer some kind of harm when there's no objective difference between the item promised and the item received. That type of transaction imposes no ascertainable loss that can support a Consumer Fraud Act claim, nor does it render a consumer aggrieved to support a TICWINA claim. And third, without an ascertainable loss, some threat of future harm, or the lack of an adequate remedy at law, the consumer cannot obtain an injunction. For each of those reasons, the court should reverse the appellate division in total. Thank you.
Thank you, counsel. Thank you to all counsel. We'll take the matter under advisement.